r/pro revenge. I'm a lawyer who was wrongfully fired. I used the law to get my revenge. Throwaway. Because, obviously, TLD Dar, senior associate at a mid-sized firm, got scapegoated for a partner's fraud and fired for ethical violations. I sued for wrongful termination/defamation, used discovery to pull emails and bank records that proved the partner had been cooking the books and framing me, got a summary judgment that restored my reputation, forced the partner into disbarment proceedings, and the firm settled for a number that paid my bills and funded restitution to the clients the partner had cheated. Feels vindicating, but also complicated. Here's how it went down. I should start by saying, I love the law. I don't say that flippantly. I got obsessed with it, the way people get obsessed with a sport or a craft. I'd spent a decade climbing at a highly competitive firm, long nights, weird dinners, endless memoranda. I wasn't a named partner. I was the kind of lawyer who got the hardest files and made them sing. I billed, I argued, I dug through contracts and found that one clause nobody else saw. Honestly, I thought that meant I was more insulated from office politics. I was wrong. It began with a large commercial client, multinational, messy, and with a partner on our side, let's call him Martin, who had been the face of the relationship for years. Martin was brilliant at schmoozing and terrible at accountability. When the client complained about inflated bills, a group they assembled to audit vendor spend, Martin told the client it was my time entries, misallocated hours, double billed, the usual. The audit flagged a handful of entries, and Martin used that to demand that the firm fire someone to show the client they were serious. Conveniently, he fingered me. They called me into a meeting. HR, managing partner, Martin. I had copies of my time entries, my work product, my calendar. I tried to explain. I had drafts, email trails, contemporaneous notes. The firm didn't want the drama or to lose the client, so they suspended me, then terminated me with a terse letter about ethical lapses and billing irregularities. The kicker, they released a short statement internally that suggested I had engaged in dishonest billing. My reputation at the firm evaporated overnight. Clients I'd worked with for years stopped returning my calls. People who once invited me to lunch avoided me. I was furious in a particular rational way. It wasn't just about the salary or the title, it was the professional death by rumor. As a lawyer, I had one thing other people didn't: knowledge of the system and the tools to use it. I wrote the firm a demand letter the day after I was terminated. It said, in so many words, you owe me process, you owe me truth, and you don't get to impugn my ethics without evidence. It was a polite letter. I think they expected me to back down. I didn't. Because the firm had accused me of ethical breaches, I had to be careful. I didn't want to commit any tactical mistakes that could be twisted. So I hired a lawyer, someone who understood bar procedure, and we filed a complaint for wrongful termination and defamation. The complaint alleged that the firm terminated me in retaliation for refusing to participate in Martin's scheme to pad invoices and to conceal client overcharges, and that their internal statement was false and caused me quantifiable harm, lost clients, lost job prospects, emotional distress. We asked for damages and an injunction preventing them from repeating the allegations. What I expected: months of motion practice and the usual firm resources thrown at me until I ran out of money. What I didn't expect was how powerful discovery would be. Discovery was the turning point. When you sue a firm that has made public allegations about your ethics, they don't just get to keep the records in a locked drawer. We served requests for production and interrogatories. We subpoenaed email archives, timekeeping logs, billing codes, the client audit materials, and bank statements tied to vendor invoices. We issued deposition notices to the partners involved. There's something intoxicating about watching a shotgun bluff unravel when concrete records are forced into daylight. Martin had used a lot of manual adjustments and shadow entries to create the appearance of overbilling. He'd routed client credits through a vendor account, mischaracterized those entries, and adjusted junior associates' time to mask it. The documents we pulled weren't just sloppy, they showed a pattern. Internal emails revealed Martin instructing an assistant to clean up billing reports before audits and suggesting we make the narrative about the associate if the client asks. There were versions of bills that never matched client invoices. The audit working papers had been edited. And critically, the metadata on the timekeeping system showed that several entries allegedly from me were entered or altered at times when I was in court or logged into my desktop in a different city. Technical stuff, timestamps, IP logs, but paper is paper. The firm had handed us the evidence when we asked for it. We deposed Martin. Under oath, he floundered. His testimony contradicted emails and the timekeeping metadata. He claimed memory lapses. That's a bad look under oath. We also deposed the managing partner, who said he hadn't seen the modified reports. The email said otherwise. The client auditors confirmed that the version of the billing report they received from the firm did not match an earlier, unaltered export that we were able to recover. At that point, the leverage shifted. The firm had accused me publicly of unethical conduct. The document showed otherwise and implicated a partner and client overbilling and concealment. There were two ways this could go for them: a humiliating trial where their partner's emails, calendar entries, and bank records were exhibits, or a settlement. We moved for summary judgment on the defamation claim, essentially saying there's no genuine dispute of material fact. The firm's statement was false and caused harm, and they acted with reckless disregard. The judge didn't grant it outright, but the motion working its way through was enough to force serious settlement talks. The firm's counsel kept asking for extensions. The managing partner's public posture softened, but we didn't stop at money. I had watched people get away with things because their partners protected them. I knew the appropriate next step was regulatory. My lawyer contacted the State Bar Committee with an anonymous tip packet. I let the investigators know I had been fired and was pursuing civil remedies, so it wasn't truly anonymous. We provided the auditor's working papers, the email chain, the metadata reports, and the deposition transcripts. I didn't want revenge by gossip or retaliation. I wanted professional accountability. The bar opened an investigation. That process was slow and sober. It wasn't public at first, and that worked to my advantage. The firm couldn't wave the ethics card in the lobby anymore without scrutiny. When the firm realized the bar investigation was underway, panic set in. Their risk profile shifted from financial exposure to existential. A partner's disbarment could sink client confidence more than any lawsuit. The firm offered to settle privately, a non-disparagement agreement, a confidential payout, and they would review billing procedures. I took none of it. I insisted on language that required the firm to release a carefully worded statement. They would retract their internal communications that accused me of ethical misconduct, and they would notify the clients that the earlier internal assertion implicating me was inaccurate. In plain English, I wanted my name cleared publicly, not a quiet check. Ultimately, they couldn't stomach the combined pressure, civil exposure, bar investigation, and the slow inevitability of more documents coming to light. They settled the wrongful termination and defamation claims for a 7-figure sum. That figure will make Reddit eyebrows raise. Yes, it happened. No, I'm not disclosing exact numbers. The settlement included a public retraction and apology circulated to the client and internally, payment covering lost wages, legal fees, and punitive damages, a provision that the firm would cooperate with the bar investigation. The bar later filed formal charges against Martin. It's rare to see a partner with that much tenure get such a fall, but the evidence was damning. Falsifying client invoices, intentional concealment, and making false statements to the firm to shift blame. He was suspended and then disbarred. The firm paid restitution to the affected client and adopted new billing oversight. Somewhat vindictively, I kept a copy of the new supervision policy and mailed it to a few of the junior associates who'd supported me. So revenge. In the most classical sense, I took a wrong done to me and used professional tools, law, procedure, discovery, to turn the light on who had actually done the wrong. I didn't hack email servers or leak personal data. I didn't break the law. I weaponized the system I'd been trained in. And it worked. That said, it wasn't purely satisfying. Getting a settlement and seeing Martin disbarred didn't instantly repair relationships or erase the months of humiliation. People at other firms still looked at me with a "did the lawyer get fired for real?" expression for a long time. The bar process was invasive and slow. I lost time I can never get back. There's an odd hollowness to professional vindication. It's a clean ledger, but not a balm for the late nights when you wonder whether you still trust people. A couple of important takeaways: if anyone else ever finds themselves in the same position, document everything. I had notes, calendar entries, drafts, and contemporaneous evidence. It was the difference between a he said, and a paper trail. Don't panic. Lawyers are very good at panicking about reputational risk. Use your head. Make the firm make the first move if possible. Hire counsel who knows the interplay between civil litigation and professional discipline. Those are two different beasts. Keep it legal. It's tempting to get theatrical. Don't. The moment you cross a line, you lose the moral high ground and expose yourself. Revenge, that's also restoration, feels better. I made sure the clients got restitution, and the firm had to fix the processes that allowed the fraud. Revenge for revenge's sake is hollow. Corrective action matters. People often ask if I celebrated Martin's downfall. I won't lie. When the disbarment letter came in, I felt a wave of relief and something cold and pleased. But that passed. My focus turned to rebuilding, new clients, a new firm culture, and mentoring juniors so they'd never end up where I did. And yes, the money helped. It bought time to pick the next job carefully, and it let me repay some people who had supported me. But the real win, if I have to put a name on it, was getting to use the law as it's supposed to be used, to rectify wrongs, to make evidence speak louder than rumor, and to hold people to the standards the profession demands. Edit. A few people asked if I'd press criminal charges. The client's auditors referred evidence to authorities. The client pursued civil restitution. I cooperated with any lawful investigation. My goal was never retribution for its own sake. It was accountability, and that's what happened. Final edit. I'm not a perfect person, and this isn't a morality play. I did what I had to, using what I know best. If you're in a similar situation, talk to counsel and document everything.